and welcome to Foley's webinar on strategies for contracting with cloud providers. This is the first in a series of health information technology webinars that we'll be presenting this year. So watch your emails for future announcements. I'd like to introduce our three speakers for today's program. Our first presenter is Matt Carlin, who is a Foley partner based in our Boston office. Matt is a member of our technology and outsourcing practice group and also a member of our privacy, security, and information management group. Matt handles a wide variety of IT transactions for healthcare organizations as well as other types of clients, and he co-chairs the Boston Bar Association's Computer and Internet Law Committee. Our next speaker will be Dan Orenstein. Dan is a repeat guest to our webinar series, backed by popular demand. Dan is a Senior Vice President and General Counsel of Athena Health, which is a NASDAQ-traded health information technology company that provides web-based revenue cycle management, electronic health records, and patient communication services primarily to physician groups. Dan is also the Vice Chair of the Information and Technology Practice Group of the American Health Lawyers Association. Our third and final presenter is Foley attorney Leanne Hapte, based in our Los Angeles office. Leanne is the co-chair of our healthcare industry team's Health Information Practice Group. She's also a certified information privacy professional. She spends a good deal of her time advising healthcare organizations on HIPAA, the HITECH Act, and other state and federal privacy laws. We'd like to take a little bit of an interactive approach with our speakers today and have them actually dialogue with each other rather than just lecture at you. We'll let you join the dialogue at the end of the program with a live Q&A session if time permits. And you can also submit any written questions that you may have during the program, and we'll take those up at the end of the program. Before we start, I'd like to go over a few additional housekeeping points. Today's program should be good for one CLE credit. New York and New Jersey attorneys applying for CLE credit have to fill out an attorney attestation form and write down the course code that we'll provide midway through the program or at the second part of the program. Finally, we really appreciate your feedback, and so we ask that you take a few minutes and complete the survey that will appear on your screen after the Q&A session. And with that, I'll turn it over to Matt Carlin.
Thanks, Mike. So as Mike said, my name is Matt Carlin. I am a partner in Foley and Lardner's Information Technology and Outsourcing Practice. For those of you who don't know, I'll share a little bit about Foley. We are a law firm of about 900 lawyers in 21 offices around the world. And I know a lot of folks who are listening today and participating today are healthcare practitioners or in the healthcare field. So one of the things you might not know about Foley that makes us unique is that we have a practice group dedicated completely to servicing the information technology and outsourcing needs of our clients. That's the area in which I practice. And what that means is that my entire practice is devoted to information technology and outsourcing transactions. And one of the types of transactions that we do and that we focus on are cloud transactions, which leads us to the presentation today. It's sure it's not a surprise to anybody listening that healthcare organizations are utilizing cloud technology at an increasing rate. Years ago, and even just a few years ago, healthcare organizations, whether a hospital or a physician practice group, perhaps an insurance company, really shied away from cloud given some of the issues that cloud services faced at the time, particularly with respect to data security. What we're seeing is that that is really no longer the case. There were three particular industries that really were late adopters of cloud services: the government, the financial services sector, and healthcare organizations in the healthcare industry. What we're seeing now is that with respect to all three of those industries, an increasing use and at an alarming rate, an increasing use of cloud services. So what does that mean for healthcare organizations? It means that your electronic health records are perhaps in the cloud, and you can access them through a cloud service. Perhaps that's where you store radiology images, your patient management system, perhaps your hospital information system is a cloud-based system. Your revenue cycle management or claims management system is perhaps a cloud-based system. And what we're seeing and what all the data is indicating is that 71% of healthcare organizations are either deploying or plan to deploy cloud technology. That number is increasing very, very quickly. And of course, the revenue associated with that is hundreds of billions of dollars, according to most studies. I apologize. Go forward here. So what is cloud computing? For those of you who don't know, it has four characteristics, common characteristics. A cloud service is delivered over the Internet. The Internet in that case is the cloud. It is something is being delivered as a service, whether it's software, whether it's your platform, whether it's infrastructure resources. Something is being provided as a service over the cloud or through the cloud again being the Internet. Cloud computing and software platform infrastructure services provided through the cloud are what we like to say scalable on demand. It means you can ramp up and ramp down the services pretty much on demand. There's no waiting period. There's no real transition program or implementation program associated with that. It's something that you can do on demand and very quickly. And the billing model is very different than the traditional billing model in, for example, the licensing arena. So in the cloud, you have utility or subscription billing, and we're going to get into a lot of the details with respect to what that means a little bit later. The types of cloud computing services, there's generally three. The one that you're probably most familiar with is software as a service, or SaaS. What that's referring to is that a provider is providing software over the cloud through the Internet, and it's being provided as a service. So you take your traditional licensing model with a license agreement where you implement an application on your servers that are resident in your place of business, and you flip that on its head. It's completely different from that. Now, what you're doing is you're accessing an application that is on a server, but it's somewhere else, and you're accessing that application through the cloud, through the Internet, via a username or password. Some of the other applications that you're probably less familiar with are platform as a service. So here we're having a development platform being offered via the cloud, and infrastructure as a service where your infrastructure resources like memory, processor, storage, those types of things are provided as a service through the cloud. So what are the benefits? There's lots. We've included a few here. This list can get very long. There are lots of benefits to cloud computing. Certainly, those of you who use it have probably identified a reduction in capital costs. Well, certainly that's the case because you're not buying the hardware. You're not investing in the infrastructure to support the application, the infrastructure, or the platform that you're getting through the cloud. Enhanced computing power. Certainly that's also the case because suddenly you're sourcing those needs through a vendor who has the ability to provide computing power that you won't generally be able to provide as an organization. Greater flexibility, we talked about that a couple of moments ago, particularly with respect to scalability on demand. You have the flexibility to increase your resources and decrease your resources very quickly without a lot of startup costs, without a transition, without implementation fees and things like that. There's lower upfront costs. That goes hand in hand with what we were just talking about. And there's the availability of in-house expertise that you don't need to hire. Now, certainly you pay for that through the fees that you pay the vendor to provide the service to you, but you're getting dedicated folks who know how to run the system, know how to run the application, know how to correct the errors quickly without having to bring those folks in-house or hire a third party to do that for you. So with respect to cloud computing agreements, I spend a lot of time, and I know Leanne does as well, we spend a lot of time working through cloud computing agreements. And they take lots of different shapes, and there's lots of different forms. Some are better than others. And some, in the cloud, they do have a similarity with respect to the old licensing agreements that we see less and less of these days. But they really do have a lot more in common with your hosting or your ASP agreements, just given the nature of the cloud service. So let's think about licensing versus the cloud and what the differences are. In the traditional licensing model, a vendor is going to install the software or the equipment in your environment. So the application will sit on a server that's in your data room somewhere. Maybe it's in your building, maybe it's somewhere else, but it's on your equipment and it's in your environment. You have the ability to have the software, the hardware configured to meet your needs, and you, of course, retain control of the data. All of that changes when you move to the cloud. So suddenly, the software, the hardware, the customer data, those are all hosted by a provider, very typically in a shared environment. What that means is that many customers might be accessing that application that sits on the same server that you're accessing the application. And then software and hardware configuration are much more homogeneous across all customers, which means that you really don't have an opportunity to customize the particular service to meet your organization's needs. And so what we see is in the cloud, we shift priorities. So when we're doing a licensing deal, we're thinking about things like configuration and implementation. We're thinking about things like acceptance testing. Those are the types of things I want to make sure that I'm able to test the software. I want to make sure that it's configured to meet my needs. I want to understand what the implementation cycle is, how the implementation fees are paid, so on and so forth. Those things become less important and really not relevant in the cloud, where I'm suddenly focusing on things like service availability. Is this thing going to be available to me when I need it to be available to me? Performance. Is the response time going to meet my needs? The service levels associated with whatever service I'm getting through the cloud. Data security obviously becomes much more important, and Leanne's going to talk a whole lot about that in a little bit. So the priorities change, and as the priorities change, how we do the deal changes, because we're suddenly focused on very different things when we're doing a cloud computing transaction. So in the cloud, what are we going to focus on? And what do I want to know? So before I go into a cloud computing transaction, there's some critical data points that I need to collect from the customer. I need to understand what is the criticality of the software. Okay, if the application doesn't work, if you go to your computer, your terminal, and you're trying to get onto the application and it doesn't respond to you, what happens? Does that mean that your communication infrastructure does not work? Does that mean your email system doesn't work? Does that mean that your hospital information system doesn't work? Does that mean that you can't input data into the system or pull data from the system? How bad is it that this thing isn't working? What are the unique issues presented by cloud computing to the environment in which you're operating? And then what are the service levels and the pricing offered? And I also want to know, and I want to understand, and something missing from this list, is what type of data am I putting into the application that's offered via the cloud? Is this our most sensitive data? Is this protected health information? Or is this generally available data that is less risky than my most critical and my most sensitive data? Those are all things that I want to collect before I start doing a deal. So with that kind of background, I'm going to shift it over to Dan, who's going to give us his perspective on cloud computing, particularly in the healthcare industry.
Thanks a lot, Matt. This is Dan Orenstein. That was a great introduction to cloud computing. One other disclosure, Athena Health is a Foley client, and happily so. And so thanks, guys. And another thing I just wanted to point out about Athena with respect to the cloud model, we often refer to ourselves as cloud-enabled service, where our service is really providing the results of the cloud environment. So, for example, we see ourselves not so much as, kind of standing on top of the SaaS model, providing the results of paid and posted claims on the revenue cycle side and results matched to orders, for example, on the clinical side, and our clients are coming to us for those specific results. So the priorities shift. As the priorities shift in the contracting area, there's a paradigm shift. We are all very comfortable with the prior paradigm of a enterprise software model, and it is harder than you think to make that shift because our old ways die hard. Here's an example of the transition from the horse-driven carriage to the automobile, and you can see that this family's having a tough time making the transition. Sometimes we as lawyers and clients also feel that difficulty. So what I wanted to do is, we don't have time to hit all of the issues. Foley's got a great white paper which hits more of them, but we want to hit the issues of service availability, and we're going to have a little dialogue on all of these What are the advantages and disadvantages? What do you want in your contract? How do you want to address service levels in your contract? Because oftentimes you are really contracting for those service levels or those results rather than a particular set of functionality. Data privacy and security, there are different issues. There's a shift in what you need to address in these contracts, and implementation is different. So we're going to hit some of those. So I'm just going to lead this off, and we're going to have some dialogue on, some things that are that might be a little bit different with regard to availability, and we'll get into some of the more specific contract terms. But my perspective is that availability, unlike some of the other issues within the security bucket, this is actually should be a real advantage of the cloud platform. And in your negotiations and contracting, you want to make sure you can take advantage of that and are protected in that regard. But overall, security in the cloud is no different in many ways than security in an enterprise system or a local client server system. One thing the cloud offers as a platform is a uniform structure where you can manage security protocols centrally and in a more uniform manner, and you might achieve an economy of scale if you have a cloud vendor that, for instance, has is a HIPAA-covered entity or is an experienced business associate or meets some other standards like SOC 1 and SOC 2. That may lead to enhanced availability. With respect to backup and recovery, the cloud enables more diverse geographies. For example, I'll use us as an example for a minute. We've got servers in Bedford. We've got redundant servers in Dallas. And offsite backup can be more readily supported in some cases. It is a possible advantage, not in all cases. Data concentration, having the data centralized. If you've got a distributed workforce, a lot of locations, mobile, remote employees, there can be the advantage of more data integrity being centralized and availability for everyone wherever they are. And disaster recovery at scale, again, having some of these built-in redundancies and executed on a large scale, some customers of cloud services can take advantage of greater capabilities than they can achieve themselves. And I'm going to turn it back for some additional discussion on service availability.
Thanks, Dan. So with respect to service availability, one of the things I wanted to point out in light of our discussion about licensing versus the cloud is when you do a license agreement, the most important provisions or most important provision perhaps is the license grant. And evaluating a license grant is something that everybody should focus on in a license agreement, making sure that it meets your needs and is broad enough to meet the particular use of the particular application that you're licensing. So where do you find the license agreement, the license grant in a license agreement? It's typically on the very first page. It's commonly even the very first provision. If it's not the first provision of the license agreement, it's probably the second provision, perhaps after some background information, maybe a definition section, but it's right there front and center. When you do a cloud computing transaction, if the focus is on things like availability and the focus is on things like service levels, and all of those very, very, very critical terms when you do your cloud computing transactions, I will promise you, and somebody on the call can certainly prove me wrong, but your most important provisions, the ones that we just identified, are probably not on the first page of your cloud computing contract. In fact, those types of provisions might not even be in the terms and conditions. Those types of provisions might be in an exhibit, which of course are made part of the terms and conditions, but it could be a separate document. Even worse, those types of provisions might be, you might have to follow a link to the supplier website to see what types of service levels the particular provider provides with respect to the application that you're getting. And so we want to really think about, how do we do our cloud computing transactions and make sure that we're really finding where these most important provisions are so that we can properly evaluate them. So with respect to service availability, what do you need? First and foremost, you need to make sure that the service availability guarantee of a particular cloud computing transaction meets your needs. What does that mean? It means that the service should be available to you when you need it. And if it's not, there should be some remedy to you associated with that, whether it's in terms of a performance credit or some fees back, or if it could be phrased as a guarantee that it will be fixed within a certain period of time. And it can take a lot of different shapes, but essentially you should be focusing on ensuring that whatever it is that you're getting, whatever service that is supposed to be available to you, is made available to you when you need it. In addition to that, there's other types of service levels that are bulleted out on this slide. For example, disaster recovery and business continuity plans are certainly important, and maintaining those is certainly a critical requirement of vendors, particularly in the space that you're all dealing with, and particularly when our most sensitive data is used and processed and stored in the particular application. Certainly we want to talk about things like a provider's agreement not to withhold services, particularly if there's a dispute between the parties, or even if there's a dispute between the parties. Certainly we can think about protections against the provider's financial instability. Keep in mind that a lot of the suppliers that you might be working with in the cloud space are younger companies, or smaller companies, or newer companies, and we want to make sure that they are going to be around for a while, and we want to evaluate and do our diligence with respect to their strength and their financial viability long term, and then provide some remedies to us in the event that for some reason we become less and less satisfied with their strength and financial viability. On the next slide, we talk about some additional service levels, things like uptime service levels or uptime guarantees. This is the availability service level. The two are synonymous with one another. When you start drafting your uptime service level, think about things like outage windows. Think about things like remedies. A lot of times what you'll find in supplier forms is that they'll give you a fantastic uptime service level. Maybe they'll call it an availability service level, 99.99999% of the time, or maybe even 100% of the time in some cases. But then they'll carve out of that a whole bunch of permitted downtime. And if you sit back and you start reading what constitutes the permitted downtime, you're going to see that, well, pretty much any downtime is permitted. And you got to be really careful about fine-tuning your permitted downtime to ensure that it's really warranted. So, for example, oftentimes we'll permit downtime for maintenance purposes, for periodic maintenance purposes. When you do that, though, understand that we don't want permitted downtime to be at a time of high use of the particular application. So if you've got data that supports the conclusion that the application is used Monday mornings at 9 a.m., at significant volumes, you don't want your permitted downtime to be Monday morning at 9 a.m. So you want to think about when is it okay for this thing to be taken offline so that the vendor can do what they need to do to repair it, to fix it, to make changes, and so on and so forth. I'm going to turn it over now to Leanne, who's going to talk about data security and cloud computing. Leanne, take it away.
Thank you. So in this next segment of the webinar, we're going to focus on data security and privacy issues, including the contractual issues related to the location of the data, security policies, issues to consider with respect to cloud vendors that provide services through subcontracting arrangements, data ownership and use rights, breach notification, and data conversion and return issues. And as I note here that this these contractual provisions may be in the form of a business associate agreement, or may be in the form of a contract, or maybe in the body of the contract, rather, depending on whether the data you will be transferring to the cloud is protected health information or other types of data. And Dan and I will be having a discussion about each of these issues moving forward. So one of the first steps in considering whether to enter an agreement with a cloud vendor includes a consideration of the risks and benefits, and in particular, whether the vendor can meet your organization's expectations. We've highlighted here certain types of diligence that are going to be important, particularly if you're considering outsourcing your data hosting. We suggest you require your cloud provider to complete a due diligence questionnaire, and we suggest that you pay particular attention to issues such as the provider's financial condition and corporate responsibility. So, for example, is the provider financially sound? Does it have a history of violations or breaches associated with it, or perhaps its subcontractors? Another issue which we will be discussing in more detail in a few minutes is the location of the data, including the disaster recovery facility. So where is the data hosted? If the vendor has multiple data centers, will your organization's data be moved between the facilities? Are the facilities in the United States? There are a variety of issues here for your consideration. The provider's use of subcontractors and contractual relationships. Here, what you're looking at is whether the provider is, if you're looking at layered services, for example, if one organization is hosting the data, another organization may be providing the software, you need to understand the scope of subcontractors involved. You need to understand the relationships between the organizations, the scope of control, and your recourse in the case of a problem. And lastly, pre-agreement due diligence requires a careful review of the vendor's security infrastructure and policies. And in this review, we think it's particularly important to include IT and legal staff because you need to understand the vendor's policies and whether the vendor's policies and procedures satisfy the compliance obligations of your organization. So here you'll want to consider the risks unique to cloud, such as the risk of a multi-tenancy environment in a public cloud, for example, or the risks associated with the services being delivered over the Internet, which your IT staff will be able to provide advice on. And you also need to consider the regulatory and contractual obligations to which your organization is bound. So in this rest of this presentation, we mentioned HIPAA, but you may also be subject to FDA regulations for electronic records, or if you maintain credit card data, your compliance obligations may extend to PCI DSS, or if you're a personal health record vendor, you're subject to FTC regulations. So we suggest you may want to, sit down and map the provider security policies to those of your organization, and you may find, that providers who work in the healthcare space may be more familiar with these requirements and may be better able to accommodate your needs in this area. And Dan, what is your experience with respect to the issues that are typically addressed in security diligence?
Well, Leanne, I couldn't agree more with the need to focus and maybe even refocus and reemphasize pre-agreement diligence. Once you get into a contract and you're receiving cloud-based services, the contractual protections you get, while they can be useful, are often going to be cold comfort when there's an incident that leads to a data breach, something that can harm your organization's reputation or jeopardizes patient care. Those are the kind of things you want to try to vet in advance. And in my experience, there's too much emphasis on contractual protections and not enough on the pre-agreement diligence. So what something I think I might suggest, especially for maybe mid-sized or smaller organizations who may not have quite as much capacity to do a full assessment and questionnaire, is to ask the vendor if they, do they have a HIPAA security risk assessment that they're, willing to share, or at least the highlights of a security statement that describes their security measures, and you can map to your needs, security needs, and your own security risk assessment, or even some type of security certification. Ask to speak to their chief information security officer or another individual at the vendor is responsible for security, and then try to get an understanding of what their DR and disaster recovery and business continuity program looks like, and then ask more questions if there's something that you're uncomfortable about.
Okay, thank you. I'm going to interrupt for a moment, and for those individuals in New York, I need to provide a CLE code. So the code will follow. It is I as in ice cream, T as in Thomas, R as in Richard, U as in umbrella, and L as in Larry. So again, the code is ITRUL for anyone in New York. Thank you. So moving forward, one of the things that you also will want to address in your contract itself are issues related to the location of the data. And when I look at it, I really see three issues with respect to the location of the data. First, there are the implications of offshoring data. So if data is hosted overseas, it could be subject to either additional compliance obligations, such as the data protection laws in European Union countries, for example. And on the other hand, it might be hosted in a country with very limited laws governing privacy and security. Generally speaking, it's going to be more difficult to assure compliance if the data are overseas, regardless of their location. Monitoring security, mitigating the damages in the event of a breach are things to think about. A second issue is associated with the laws and contractual requirements that you're obligated to comply with. For example, Medicare Advantage plans and Medicare prescription drug plan sponsors must satisfy CMS requirements to submit detailed attestations for each offshore contractor that they've engaged regarding how they address the risks associated with the use of a subcontractor outside the United States. If you're a participating provider of one of these organizations, you might be precluded from offshoring data through your contractual agreement, or you might have to submit the same documentation to the Medicare Advantage plan or PCP sponsor if you decide to offshore. So that's something to consider. In other states, such as Illinois, is a recent example. The Department of Insurance has issued a bulletin stating that third-party administrators and utilization review organizations are precluded from not only offshoring data, but also having any operations performed offshore. So that's kind of a second point of consideration. And even if the data is not hosted overseas, location remains a consideration nonetheless because of the great variation among state laws with respect to privacy and security. So, for example, in some states, laws apply only to certain healthcare providers or data on state residents, but that is not always the case. In other states, such as Nevada, for example, the laws governing health data apply to organizations doing business in the state. California medical privacy laws apply to, among others, businesses organized for the purpose of maintaining medical information. So these organizations may be subject to the same laws as healthcare providers with regards to the privacy of medical information, And the data that you maintain in these states may be subject to the liability associated with violation of laws in those states, including civil penalties and perhaps right of action. So, private right of action. So with respect to how these issues could be addressed contractually, you may want to consider prohibitions on offshore work. However, if the data is not hosted offshore, there oftentimes may be personnel such as developers and others who are located offshore. So that will be an issue that you will want to give consideration to in your negotiations. Another provision, you may want to prohibit the transfer of data without prior approval, and we generally recommend that. But again, your ability to negotiate these issues may vary depending on the size of the vendor, the size of your organization, and the nature of the services. So those are just a few kind of high-level points. Dan, what do you see as some of the key issues with respect to offshoring?
Yeah, Leanne, I agree with a lot of that. You won't be surprised that I take issue with some of what you said at the end, and you know, I think that in some cases you are going to want to restrict where the data goes and offshoring if you're not confident in the capabilities of your provider. But in other cases, just going to the next slide here, I think this is where the world is going, is ultimately towards comparative advantage and letting folks who process data most effectively and efficiently do so, assuming it's secure enough, and you've got the protections in place. I think that we're all probably coming to realize that more than we're willing to admit, our data and health information is being processed offshore. Diligence, again, is really important. You know, it is harder, you know, looking at the major issues this raises. It is harder, it can be, if you only have an entity abroad to hold accountable. If you've got a U.S. entity or some ability to hold an entity accountable in the U.S., that's better. I agree that the laws may not be as protective abroad. And on the other hand, in some cases, the culture of security is better abroad, and there's less of a concern or about kind of data, or less of a cultural assumption about data mobility and access to the internet, and things that we kind of like to have, you know, here in the United States and, you know, in a lot of Europe. You can actually get some pretty good practices abroad, but diligence is really important. So I'm moving to the next slide, 21. And Leanne, I wanted to address some of your comments also on these kind of state-imposed limitations and private limitations. My point of view on like the Illinois Bulletin, and we've seen something in Arizona, is that these provisions are pretty rare. Under U.S. treaty, you would be shocked, right, if a state or, you know, a local jurisdiction were to prohibit the trade of goods to a country with which we have a treaty for the free trade of goods. We also have general agreement on trade and services, you know, a U.S. treaty which has the supremacy, the federal supremacy clause. And this is my theory, is that this is what is making it very rare, because if it actually becomes more widespread, folks would realize that they have a constitutional problem restricting trade and services with our allied countries. But, you know, these things are out there, and you've got to look at them. We have a few times in the past, but what I thought would become a very major issue several years ago has really kind of just remained status quo. It's a very rare issue. And then private limitations. This is a real issue, And if it's not in, it might be something you want to impose if you're not comfortable with where the data is, but it's also something that vendors might struggle with if their sourcers, the items and services they're getting from third parties, put a restriction on offshoring. It's something we're looking at now as an issue, and it's again, I would where I think we're all going is comparative advantage processing of the data where it's secure and most efficient to process it. You know, when you're looking at business process outsourcing, we found that a lot of the better entities will have an ISO 27001 certification or some other evidence of real data security that you can rely on.
Well, I think this is I appreciate your comments, and Dan, I think this is a very interesting issue, and it's not going to go away. So it's something that, you know, organizations need to just think about with respect to their particular circumstances and contracts. So I'm going to touch briefly on some other issues related to data security, and generally what I would like to discuss here is the issue of verification of a cloud provider's compliance and the way that organizations might monitor some compliance. And here I think what organizations need to be thinking about, at least those that are subject to HIPAA, if we're talking about protected health data in a cloud environment, is what do you need to help you be able to respond to an audit? You may need access to the facilities at certain times to determine HIPAA compliance. You will need, you will need evidence of compliance, and although it's not typical that you would individually audit a cloud provider, you may want evidence of an external audit or a third-party audit, which Dan's going to talk a little bit about, to provide evidence that of compliance on an ongoing basis. And another issue that it's important to consider with respect to compliance and preparing for an audit is really thinking about how your policies and those of your vendors are coordinated and documenting them in your contractual agreement. So as a very simple example, if your vendor is managing user authentication, for example, you need to ensure that you have a security policy that adequately informs the vendors of changes in the employees or the persons or organizations on your end that are to have access to these data, and in order to ensure that responsibilities are clearly understood between the parties, we suggest you identify them in your contractual agreement. So Dan, what advice, can you tell us about what advice you have on how to approach monitoring of security and compliance in a cloud environment?
Yeah, I think there are certain things, Leanne, you're going to want to be notified of, a security incident, a data breach, and you know, something that happens that concerns your organization. You're going to want to have a contractual provision that lets you know that happens. You can work with the vendor to fix it. On the practical side, from my experience, you know, we do get some requests for ongoing audits, and for, you know, for our very largest clients, sometimes we've got to do that. But, you know, like a lot of large organizations, you're already busy with a lot of audits and a lot of other work, and the vendor is often already busy with multiple external audits and internal audits. So sometimes that may not be the most practical thing to do going forward, and you might not do the audit that you set out to do. So are there substitutes available? Does the vendor have a SOC 1 or SOC 2 certification, or a high trust audit that they'd be willing to share, or some other information or certification that they'd be willing to share on a regular basis? And that may get you the assurance that you need going forward.
Right. So one of the things I think it's worthwhile to mention here, without going into great depth, is that, as I mentioned earlier, there may be layered services with your cloud provider, and even if you have a great agreement with that provider, it's important that you ensure that those same contractual protections extend to the organizations with which it subcontracts. As you know, if you deal with HIPAA, HIPAA compliance, if protected health information is involved, requires that the subcontractor agree to the same conditions and restrictions associated with the protection of PHI as the contractor. If your third party is operating a data center, you may want to look in particular at whether the third-party host complies with the key terms of the agreement with the provider. You may want to consider liability issues and scope of responsibility so you have adequate resource. And you may want to consider entering into a separate confidentiality agreement with the third-party host. We don't have a lot of time left, so I'm going to be very brief here on this particular issue. With respect to breach notification, there is not necessarily so much that is different with respect to a cloud provider as compared to an EHR vendor, for example, that is not cloud-based. But one thing I want to emphasize is that, as you know, HIPAA sets out the requirements for business associate agreements, but it doesn't address these really key issues to determination of responsibilities and liability. So we really recommend that your business associate agreement or your contract, if you're not dealing with PHI, establish the procedures and time frame for reporting breaches, the roles and responsibilities of the party with respect to investigation of any breaches and notification of any individuals, access to records of investigation, what is accessible, for how long, etc., and the liability of the provider for breaches of your private information or your information. With respect to breaches, we generally suggest that customers should have sole control over the timing, content, and method of notification. And if the provider is responsible for the breach, that the provider reimburse the customer for its reasonable out-of-pocket expenses in providing notification, mitigating the harm, and other reasonable expenses associated with compliance with the law. Of course, there's also the broader issue of indemnification, which has to be considered, but, you know, at this point I'm just going to say it is subject to negotiation between the parties. This is an issue that's often negotiated. Dan, what are your thoughts on this issue?
I like that idea of negotiation. My thought on this, I'm going to go back to the pre-agreement diligence. When the rubber hits the road, the contract provisions will go so far, but you want a vendor you can work with. A vendor wants a customer they can work with, and trust and coordination, my last bullet here, are really the key, and sometimes more important than what the contract says. You've got to have a unified approach. I think is really important. You've obviously got to determine where the breach happened, but sometimes those are academic issues, and a unified, coordinated approach is going to do a world of good in terms of preserving your reputation and reaching out to patients that might be affected.
So another key issue we think you should look at are the data ownership and use rights and your contractual agreements. And here, we recommend clear language regarding ownership of data and specific language related to the provider's obligations to maintain the confidentiality of such information, and placing appropriate limits on the provider's use of customer information. Now, as Dan is going to talk about, it may be the case that not all the information you possess is information that you own. For example, if you're a personal health record vendor, the data will be owned by the individuals. Genetic information in some states is owned by individuals. That's something to be accounted for in determining the limitations on use. So we generally suggest you look closely at limiting the provider's use of data in aggregate or de-identified form, understanding what the eventual uses of such information would be, understanding if you're able to do this in compliance with the law. For example, use of aggregate data must be for healthcare operations purposes. And lastly, the recent Office for Civil Rights guidance on de-identified data, I think, suggested a couple of things. First of all, you might consider requiring the provider, if you're having the provider de-identify the data, you might require indemnification in the event that PHI is not properly de-identified. You might also consider a data use agreement associated with de-identified data because, as was suggested in the recent report, data that is de-identified today may not be considered de-identified data, 10 years from now, and you don't necessarily want to give up permanent rights to such data, even if you have the ability to do so. Dan, what are your thoughts on this issue?
Yeah, thanks,
I'm
Lynn.
sorry.
Did you want to hit that next slide, or do you want me to respond to that?
I think you should respond.
Yeah. I think that given we're running out of time, we want to leave a few minutes for questions. I think that this is another example of the paradigm shift and the priority shift. EMRs, for example, will be less and less a thing that you license with a bunch of functionality and more a clinical workflow processing engine. And the data is going to come from all over the place, all different sources, payer content, provider content, patient-generated content. I think there is a place for protecting unique intellectual property, and I would put de-identified data in some cases into that category. And if the provider generates unique IP from it, great. I think that should be protected as owned material. Otherwise, I think permitted uses and disclosures are sufficient, and what the contract should focus on, making sure that, and the law also provides different things about ownership and custodianship of the record. The patient owns some stuff. The provider is often a custodian, but not really an owner. Sometimes they are an owner. So permitted uses and disclosures is kind of the approach I like to see. With some exceptions for unique content, and then de-identified data. I think in the new world we're moving into is going to be something of great value, both to the vendor and the use of that, by the vendor or by the client, to move forward with evidence-based medicine and better outcomes reporting and reimbursement, participation in reimbursement programs. So I think we're moving in that direction. And the next part is just kind of, I think you already mentioned, in terms of the contract, make sure you've got what you need in terms of uses during the term of the contract, but also post-contract. I think you want to look at how do you get your data back, how do you get it into a new system if you need to get into the data into a new system, et cetera. And we've got another slide, but it's almost at the hour, so I wanted to hand it back to whoever's coordinating questions.
Okay, that's me, Mike Scarano.
Mike, thanks.
And we do have a couple of questions, which I'll read here, and then if we get through those, we'll take some live questions. First question is regarding cloud providers, namely AWS, who takes the approach that they are a conduit and not a business associate. Based on guidance from the ONC, I think that they make a good argument for being a conduit. However, no specific guidance has been issued. What do you think?
I can start out to respond. I mean, certainly it's circumstance specific, but it depends how long, whether they have access to any PHI, even for troubleshooting. If the data is passing through when we look at an interface or something like that, you know, technically, even if that data is in that interface for a limited amount of time, it still could be considered subject to HIPAA. So organizations will want to argue both ways. I mean, most vendors would prefer not to be business associates under HIPAA. I can't give a specific answer with respect to a particular situation. I would say there are arguments, and they may or may not be correct.
Okay, anyone else want to add to that answer?
This is Dan. I would just add, do you as the customer, trust that vendor without the business associate protections? And if you want them, you might want to push them to have, you know, to say they're a business associate or have something very similar.
Okay, our next question is, assuming the most critical elements of the cloud agreement may be in one or more of the exhibits that are reached through a link or are otherwise not embedded in a fixed agreement, and if the vendor's terms and conditions permit it to change these, and the provider takes a hard line and is not willing to lock in certain key provisions, what practical guidance could you give to a healthcare provider or other prospective customer in negotiating the cloud agreement? What protections can the customer realistically expect if the vendor is large and not willing to negotiate much with respect to terms and conditions?
So, hey, Mike, this is Matt. I think that question was probably to me.
Okay.
And the unfortunate reality is that there's not a lot of protections you can get. There's a lot of vendors out there who provide services that a lot of folks on the phone probably get, where the contract is just simply not negotiable. That happens frequently. And so what we always advise our clients to do, and what you all should do, is first and foremost, even in a non-negotiable situation, be sure you read the materials. So many people don't because it's not negotiable. That's not a reason not to read it. It's not a reason not to understand it. And it's not a reason not to understand the risks associated with it. That being said, after you read it and after you sit back and get over your frustration that you're not able to negotiate particular provisions or protections that you're interested in, take a look back, take a step back, think about where you are on the spectrum. Are you in that bucket where you are using a non-critical service with no sensitive data, or are you in that bucket where you're using an extraordinarily critical service with extraordinarily sensitive data, or more likely than not, are you somewhere in between those two extremes? And given where you are on that spectrum, start to think about what the implications are to you with respect to what the vendor's offering and what they're not offering, and see if there's any ways that you can look at your infrastructure, look at your network, look at how you're using the particular service that's offered via the cloud to protect against those risks. But the unfortunate reality is that there are a lot of vendors out there who just simply won't negotiate the terms of their agreements. I will tell you that is less and less frequent as you go into that high-risk category. As you move from the low-risk category, which is low criticality of service and low data sensitivity, through the spectrum up to the high-risk category where you're dealing with a highly critical service with highly sensitive data, more and more vendors will be more than willing to come to the table with respect to terms that meet your needs and meet the needs of your users in your particular environment. Look at the service level agreements that they offer, and when you get to that high bucket, the high end of the spectrum where you're dealing with a highly critical service with highly sensitive data, think about what your organization needs, think about the protections that you need, and then just simply in response to the vendor's terms, initial terms, draft some terms back to them that will meet your needs. And I think you'll find that as you go through the spectrum from low risk to high risk, you'll find that you'll have far more success in the high risk categories.
Okay, well, we're out of time. We appreciate everybody's attendance, and we ask that you take a moment and fill out the evaluation. And as I mentioned, we're going to have some subsequent webinars on health information technology issues. And we've also got a white paper on cloud computing on our website. We'll send that out to all of you, and it covers pretty much all of what was covered today and then some. So we encourage you to take a look at it and provide us with any feedback you may have.
Hey Mike, the only thing I'll conclude with, I do see that there's a couple of questions that we didn't get to. All of the presenters' contact information is at the end of the presentation. Please feel free to email your questions to any of us, and we will very promptly get right back to you with a more detailed answer.
Absolutely. Okay, thank you, everybody.
Everyone, that concludes our conference call for today. Thank you all for your participation.